So what's the plan for today? What are we doing?
The vision in my head is that you had come up with some, like, hard-hitting legal questions, and then we find out how much I know, and then also just kind of let the conversation flow off that, because there is some funky shit that happens with the law, so.
Well, I have done a little research, and by that I mean about 15 minutes. So, I'm very prepared.
Perfect.
This is the Experience Podcast with me and someone else.
And lawman.
Yeah, a future lawman.
That's true.
Nathaniel is back. He's ready to, I guess, test his knowledge. So, I wasn't sure what kind of questions you want. I just Googled, bar exam sample questions.
Oh, no.
Which might be a bad idea because I'm not sure how much you're going to know after just a year.
Oh, no, but also, let's be clear. Law school does not prepare anybody for the bar.
And that too, I was gonna say, you're really more. Yeah, it's kind of this might be, but it's multiple choice. You know, I have the essay ones, but I don't know.
No,
those are super long.
I was hoping for something I can't actually think of a good example off the top of my head. That's why I wanted you to make.
Yeah,
something if I cut my tree, or if my neighbor cuts their tree and it knocks into my tree and then the fence breaks, whose fault is it, or something stupid like that.
I think I think these some of these bar questions are kind of along those lines. So I think you could probably reason your way through them.
Also, wait, what state are we in? As if I know anything. I don't know. I don't literally know one thing that's different.
This is the multi-state bar exam, so I think it's pretty generic. Great. Yeah, I did find some other ones. I found a New York essay one. But I feel like that's too much. I didn't want to. So I was trying to find good questions, and some of these these essay questions, the question itself is multiple pages.
Because they give fact.
I don't feel because I don't think we need to read all that. I didn't want to read all that on the show. So
no, yeah.
If we get to it, and then I have some other stuff here, some marriage. This looks like a marriage question.
Oh, okay, nice.
I don't know how much. Anyway, so, yeah, again, I wasn't sure what type of law questions you wanted, so I just kind of...
This is going to be so disappointing, because I'm going to know nothing.
Well, that's kind of...
What have to learn?
Well, yeah, we'll see what happens. I mean, I don't... What am I supposed to look up? Basic law questions for dummies?
No, I don't know. I just...
Because I don't know anything about law, so I wouldn't even know what to look up. You know, we're kind of...
The point was, because you don't know anything about law, I was hoping you would have some stuff where it's I don't know this thing about law. How interesting would that be to know? And then to be well, what do you know? We talked about that in my property class or something like that.
All right. So I found some other a little more basic questions that we can also go through. So if you struggle in the multiple choice bar questions, we can go to these basic.
Okay.
What is for example, one of them that's super easy is what does the O in EEO stand for? So, stuff like that. Okay. So question number 1. Do I want to start with this one? Let me make sure the answers are at the bottom here. Okay, they are. At first I was I'm going to find something without the answer, so I won't even know. All right, so this looks on the surface, just looking at it at a glance, I think you could get a lot of these. Okay. A father lived with his son, who was an alcoholic. When drunk, the father lived with his son, who was an alcoholic. So that implies the son is an alcoholic. When drunk, the son often became violent and physically abused his father. As a result, the father always lived in fear. One night, the father heard his son on the front stoop making loud, obscene remarks. The father was certain that his son was drunk and was terrified that he would be physically beaten again. Yep. In his fear, he bolted the front door and took out a revolver. When the son discovered that the door was bolted, he kicked it down. As the son burst through the front door, his father shot him 4 times in the chest, killing him. The son was not under the influence of alcohol or any drug and did not intend to harm his father. At trial, the father presented the above facts and asked the judge to instruct the jury on self-defense. So the question is, how should the judge instruct the jury with respect to self-defense? And I have, it's multiple guesses here.
Okay, wait. Before you give those, I want to just lay out some initial thoughts. So wait, this is actually perfect because this is a crazy thing that we learned. So a big thing.
See? Okay, look, give me credit here. I found a good question.
No, yeah, you're doing great. This is excellent. So a big thing that's just absolutely bonkers that we learned in criminal law is that there's a thing called the imminence requirement. Yeah, we call it crim. There's a thing called the imminence requirement, which is basically that you are not allowed to propose self-defense unless the danger is imminent. But the thing is, imminent is a pretty tight term. So the thing is, like, in this situation, right, the history of continued abuse from the son actually does not matter at all. Like, the judge is not allowed to factor that in when instructing the jury. Now, this is, let's be clear, super controversial because, I mean, how ridiculous is that? Like, if something happens 100 times and the same pattern unfolds, you should be reasonably certain that's going to happen again. But technically, like, the danger to your life or bodily harm needs to be imminent, as like it is happening when you do the self-defense. So if it's literally like the dad is like standing like 10 feet away from the door, and the second it gets bolted or knocked down by the son, he starts shooting him, I don't believe that the judge is allowed to instruct the jury for self-defense because the danger from the son was not imminent in general. Now, here's something that I'm not totally sure that might come up. There's also something called the castle rule, which is basically you are not expected to have to like run away from danger if it's in your house. You're allowed to like protect yourself in your house. You don't have to leave it to get away. So what might complicate that a little is that the house is like the father and the sons. Presumably that's both of their domiciles. So I don't know exactly how that plays in, but I'm pretty sure all that's going to matter is that the dad lives there, which means he's allowed to protect himself in the house. So I'm not 1,000% sure at this moment, but I do know that like the history of abuse is not going to be allowed to factor into this.
Yeah, so the options here are pretty, like, they're what you would expect them to be, right? It's like, give the self-defense instruction because so A is give the self-defense instruction because it expresses the defense's theory of the case. B is give the self-defense instruction because the evidence is sufficient to raise the defense. C is deny the self-defense instruction because the father was not in imminent danger from his son. And D is deny the self-defense instruction because the father used excessive force.
Okay. Just because of everything I led with, I'm going to go with C.
So this answer key says the correct answer is B, which is for those.
Give
the self-defense instruction because the evidence is sufficient to raise the defense. Okay, I guess that must be the castle rule thing, because the son did like break into the house. Yeah, so when the son discovered that the door was bolted, he kicked it down and burst through the front door. Yeah, okay. I guess technically that's enough. That's a good question, though. The father heard his son making loud, obscene remarks. And you got the loud, obscene remarks, you got the bursting through the door. The problem is the loud, obscene remarks still don't necessarily mean it's imminent. Yeah, okay, so, maybe. I mean, I don't know. I'm just trying to... I have no idea. Okay, so the next one is like a railroad crossing situation. Oh, great. Right, so the second question. A man sued a railroad for personal injuries suffered when his car was struck by a train at an unguarded crossing. Yeah. The major issue is whether the train sounded its whistle before arriving at the crossing. The railroad has offered the testimony of a resident who has lived near the crossing for 15 years. Although she was not present on the occasion in question, she will testify that whenever she is home, the train always sounds its whistle before arriving at the crossing. Is the resident's testimony admissible? So again, she's not there. She's not there at this scene, but she's lived there for 15 years. She's always heard the whistle.
Yeah. Okay, this is too bad because I'm going to talk about something that is not exactly where the question went. But there's a very famous tort case where this guy was like walking on a path next to a railroad track, and one of like the doors of one of the train cars was like open for no reason, and the train is just like bolting ahead, and the guy has and it's dark, so the guy can't see, but he has no reason to think that any of the train cars are going to be open, and it like knocks him in the head, and he might have died. Or no, he got severely injured. But the court held that like, look, when you walk on a path next to a train track, you need to know that there's a chance that like something bad's going to happen. And since you put yourself in that situation, you need to be aware. So I was hoping that when you started the question, it was going to be something like that. But to the actual question, I don't think. Okay. So like, what are we balancing here? If there's like a sincere pattern of.
Well, let me read the options then. Maybe that'll help. Okay.
Well, wait. Let me just talk about the two things that are balancing. Okay. So like a clear pattern could show that it was like more likely to happen, but at the end of the day, it doesn't speak to like the actual facts. So the question is like, is the testimony going to like prejudice the jury more than it provides like substantive evidence of what occurred? And
does that matter though? Like you're not judging whether it's good evidence, you're judging whether it's admissible, right? Or do those mean the same thing in this case?
Kind of, because like there's a rule with admissibility where like it needs to, if it's gonna like bias the jury, that has to be outweighed by the actual like substantive fact finding that it gives to the jury.
Okay. So, let me read the options. So A. So the question is the resident's testimony admissible? Again, we got the railroad crossing. This resident has lived there for 15 years. She's going to say, yeah, I always hear the whistle, but this guy is trying to sue for not hearing the whistle. Just as a recap. So is the resident's testimony admissible? A. No, due to the resident's lack of personal knowledge regarding the incident in question. B. No, because habit evidence is limited to the conduct of persons, not businesses. C. Yes, as evidence of a routine practice. Or D. Yes, as a summary of her present sense impressions.
Okay. I think I have it down to a 50-50, but I don't even want to say in case it's not one of those two. What was A again? No? A is, where am I? Yeah, A is no due to the resident's lack of personal knowledge regarding the incident in question. Alright, I'm actually going to go with C. C is yes as evidence of a routine practice. Oh, that sounds bad. You got your first one right. You're wrong. It was A? It was C. Yes. As it was C. Yes. Practice. Let's go. Okay. That's I guess maybe 15 years is enough because of the balance I was saying before. If it was like 1 year, maybe they'd be like, I don't know if that's sufficient, but perhaps a 15-year pattern is enough to say like, see, there's pretty good odds that it actually happened. So these are tough though. Yeah, but I think this is enough in your wheelhouse. Like, I think. Yeah, like I'm not totally clueless. I'm not just straight up guessing. That's what I mean. Yeah. I had it down between A and C, so. You undersold yourself. You're doing okay so far. Yeah. Only a 1-0. Okay, the next question. Are you ready for the next question? The next one is about schools.
So this one I'm going to have to, because the question is so I'll just say the question before I get into the background. Which of the following statements about this law is most accurate as a matter of constitutional law? Okay.
In common law right now.
So there's like 4 options. I'll read those after I read the first paragraph. So, to keep its public school expenditures under control in a time of increasing costs, a state passed a law providing that children who have not lived in the state for at least 1 year cannot attend public schools in the state. So again, the question is, which of the following statements about this law is most accurate as a matter of constitutional law?
Okay.
So your options. A, the 1-year residence requirement is valid because it does not affect any fundamental right or suspect class. B, state durational residence requirements that are established for publicly funded services are constitutional because they relate to government operations reserved exclusively to the states by the 10th Amendment. C, because publicly funded education is a fundamental constitutional right, a state may not deny it to any class of persons who reside in that state. And then D, state durational residence requirements established for this kind of publicly funded service solely for the purpose of reducing state expenditures violate the privileges or immunities clause of the 14th Amendment.
Oh, shit. Okay.
I can read it all again if you want.
No. I don't... I'm afraid to say stuff because it's going to be like the first thing I say is like, actually, that's the answer. But I don't think it's B because I don't think the 10th Amendment goes like, well, actually, no, I'm not 100% sure. But there's like preemption. So like federal law is like, how do I put it? Like you got to follow that first. And then the state laws kind of fill in the gaps. Now a big thing there is the federal government only has specifically enumerated rights. That's the whole point of the 10th Amendment. Like federal government can do what the Constitution says, but if the Constitution is silent on something, then that's a state right. Dang. Yeah. This is so the way that like con law works here is there's like a bunch of different con law classes. Usually at a lot of places the first class is like a very generic overview of kind of everything, but ours is like split up. And so one of the classes is a class specifically on the 14th Amendment, and I'm not in that one. So I don't really know enough about due process as it applies to the states. And because of that, I'm going to say that D is the answer.
Well, you guessed right.
Let's go.
Maybe not for the right reason, but you got it.
It does make sense. I wouldn't have said it if it was like, no way.
So this is a violation of the 14th Amendment, basically. That's the correct answer.
Yeah.
Okay. So there you go. Constitutional law.
Okay, we're on a roll.
Yeah, you're 2 for 3, technically.
50-50 on the first one, and then good since then.
Okay. So we got some neighbor stuff, it looks like, for number 4.
Oh, I like neighbor stuff. Usually torts.
Yeah, there's property. So there's 21 of these. We're not going to get to all of them, but maybe we can do like a part 2 of this.
Okay.
Because these are good. These might be good. These are supposedly sample of our questions, so they're going to be relevant to what.
I'm having fun also.
To what you're going to need to know, and maybe people are learning. Don't cross the train track. Number 4, a man has 4 German Shepherd dogs that he has trained for guard duty and that he holds for breeding purposes.
Mm-hmm.
The man has "Beware of Dogs" signs clearly posted around a fenced-in yard where he keeps the dogs. The man's next-door neighbor frequently walks past the man's house and knows about the dog's ferocity.
Yep.
One summer day, the neighbor entered the man's fenced-in yard to retrieve a snow shovel that the man had borrowed during the past winter. The neighbor was attacked by one of the dogs and was severely injured. So your question is, in a suit against the man, is the neighbor likely to prevail? And you can read the questions. You can read the options whenever you're ready.
A fun connected thing that this does not apply to exactly, but there's a rule with like animals Basically, it's like the first bite is free. So basically what that means is like if you have a dog and the first time it like attacks somebody, you get off basically because you can be like, well, how was I supposed to know that like my dog was going to bite somebody? But then after that, you're strictly liable, which means like it doesn't matter like, yeah, all these factors that kind of go before that don't matter anymore. Strictly liable is just like if it happens, you're on the hook, and then you go from there. But because of the like all the beware of dog stuff and the neighbor pass it all the time, I'm pretty sure the neighbor is like required to know that the dogs are capable of that. So I don't know exactly what like the thing after yes or no is going to be, but I'm pretty sure that the neighbor is not going to prevail. Like he should have.
Let me give you the yes or no.
Yeah.
So A, no, because the neighbor knew that the man had dangerous dogs in the yard. B, no, because the neighbor was trespassing when he entered the man's property. C, yes, because the neighbor was an invitee for the purpose of retrieving the shovel. And D, yes, because the man was engaged in an abnormally dangerous activity.
Okay. It's not B or D. It doesn't matter if you're trespassing. And it's not D because I don't think he was engaged in an like getting a shovel isn't abnormally dangerous. Okay. So the whole invitee, there's like 3 classes. Damn, I hope my torts professor doesn't hear this because he's going to be so sad. But there's like 3 classes of like people, or like 3 classes of like reasons why people can be on your property. It's like licensee, invitee, and then I forget the word, but like business. So it's not business. And then licensee is actually when like someone's coming over as like a guest. And okay, I'm not sure he was an invitee even. Okay, but if he was an invitee, then it is the dog owner's responsibility to like control his dogs if the guy has a reason to be on there. Oh, so maybe the trespassing thing does come into play. Damn, this is getting pretty technical. All right, for the sake of time, I'm just
think that's the whole purpose.
I know. And also, I wish I could like go back and like open up my torts notes and like, but that's not good podcasting. So yeah, for the sake of time, I'm gonna go with A. Yeah, but I don't feel great about it.
You're going with A? The way you answered that was A.
Yeah. Well, A is no because the guy should have known that the dogs might attack him, right?
Yeah, that's what that is.
But he did have a reason to be on the property. Yeah, I'm still gonna go with A.
All right, A is the correct answer.
Let's go.
You started there and you circled around to all the other answers, but you should have just stuck with it from the beginning. Yeah, I guess you got to know when the dogs are dangerous.
Yeah, so I wish I actually could have a chance to look up the 3 classifications of whatever thing. Although what's interesting is a lot of states have moved away from that, so they don't really care why you're on the property anymore. But it sounds like he did kind of invite himself. So anyway.
All right, maybe we'll do one more. We'll get 5 questions. I feel like that's good. That's good. That's the whole first page of this. So
I'm already over 50%, so I'm chilling.
And number 6 is super long, so that's why we're stopping here. Yeah, so you're 3 for 4, but it's a soft 3 for 4, I would call it. You know,
what does that mean?
You know, it's a non-confident 3 for 4. You know.
Yeah. No, but
like you faked your way to 3. You faked your way to it, but you worked it. Number 5. All right. A woman from State A filed an action against a retailer in a state court in State B.
Oh, this is going to be Surf Pro. Fuck yeah.
The complaint alleged that the retailer had not delivered $100,000 worth of goods for which the woman had paid.
Over $75,000, which is the requirement.
Okay.
Yeah, but the requirement for like if two places are out of state, if like two parties are in different states, then in order for it to go to federal court, the amount in question needs to be over $75,000, which it is. So just had to throw that in there right then. Continue.
Yep. 20 days after being served, the retailer, which is incorporated in state C, so again, the woman's from state A, the retailer against a retailer in state court in state B. Now, 20 days later, the retailer, which is incorporated in state C and has its principal place of business in state B, filed a notice of removal in a federal district court in state B. Was the action properly removed?
Oh, okay. So also the 20 days is relevant because I'm pretty sure you have to do that within 3 weeks. So these are nice numbers. Okay, so wait. If they remove it, that means they're moving the jurisdiction. But, oh, shoot. This is brutal because I know that if I went in my notes, I could just, like, get the answer straight up. But, so, oh, no, wait. So the lady in state A is suing the company, right?
So a woman from state A is filing an action against a retailer in a state court in state B.
Oh,
the retailer
court in state B, and they're trying to remove it to federal.
The retailer, incorporated in state C, has its principal piece of business in state B, filed a notice of removal in a federal district court in state B.
Okay, great. So okay. I missed out the first go around, but just to clarify what I was talking about before.
I'm still lost, but go ahead. Yeah.
Okay, yeah. So no, I'd love this. Like I said, the civil procedure. That's been my best class in law school so far. So it helps a lot to have the federal rules of civil procedure pulled up, so that I get to like actually look up stuff and reference it. But so here's what's going on, right? So kind of like we were talking about with the 10th Amendment thing, right? There's like state courts and there's federal courts, and so like yeah, basically they're just different things going on. Like sometimes you can only sue in federal court if it's like, you know, a federal statute that's being violated or something like that. But a lot of times for like torts and claims like this, it's settled in state court. If instead of like state A, B, C, all that nonsense, if everything was state A, they would not even be allowed to try to hear it in federal court. They would have to hear it in the state court of state A because it's contained within the state. So there's no reason to get like the federal government involved is basically the idea. So removing, what that term means is basically like it's something's in state court, but one of the parties says, I would like it to be in federal court instead. And the reason why is because that's a little nuanced, but like sometimes the rules are a little different, or like the way they get juries is different, or even like the judges. It's a little bit of like gaming the system in some ways, kind of. Technically it shouldn't matter because a court should just like find one way or the other. But the real reason they do it is to like prevent bias. So, you know, if like one state might be like trying to subconsciously like protect their interests in their state, and so they're more likely to rule against. So anyway, you take it to federal court, so there's no state bias. Okay, so the amount in controversy is satisfied. That's the first thing I said. It has to be over $75,000, which it is. The second thing is I believe you have to make that notice within 3 weeks. So they said 20 days. So I'm not seeing a reason why they couldn't at least ask for it to be removed. There might be something about like if the plaintiff or defendant can ask for it to be removed. But I think because the defendant's the one being sued, they're the ones who typically get to initiate that process. Oh, that's the only way it makes sense. Because if the plaintiff wanted it in federal court, they could have just brought the action in federal court. So I'm not seeing a reason why it couldn't be removed.
All right, so let me read you the options.
Mm-hmm.
So again, was the action properly removed? A, no, because the notice of removal was not timely filed. B, no, because the retailer is a citizen of state B. C, yes, because the parties are citizens of different states and more than $75,000 is in controversy.
Mm-hmm.
D, yes, because the retailer is a citizen of both state B and state C.
The fact that it's two states shouldn't matter because I believe, if I remember correctly, when it like the thing actually takes place in state A because that's where her stuff didn't get delivered. So I'm pretty sure it's C. I think it's timely. I think it's 3 weeks, so the 20 days is good.
So the correct answer is B, no, because
No.
the retailer is a citizen of state B.
Really? What?
Yeah. I don't know. How am I supposed I was just reading the answer.
I wasn't really asking you. Wait, huh? Oh, man. Now I hope that my Civ Pro professor doesn't hear this. Wow, wait. Okay, so
let me reread the question, okay? Because it gets a
Yeah.
little confusing about who's where and who's doing what. So the woman is from state A, filing an action against a retailer in a state court in state B. Okay, it's over $100,000 worth of goods, 20 days after being served. The retailer is incorporated in state C and has its principal place of business in state B, filing a notice of removal in a federal district court in state B. And so the answer is no, the action was not properly removed because the retailer is a citizen in state B.
I didn't know that you could do that. So I do know that corporations have two citizenships, quote unquote. One is where they're incorporated, and one is where their principal place of business is. So, I mean, yes, I did know that the corporation was a citizen of state B, but I didn't know that prevents them from removing it to a federal court. Because the whole point of federal court is that, like, it doesn't matter what, like, citizens people are states of, I thought. So, I'm surprised.
Yeah, I guess you got to go through the state court first, and then you can go to the federal. I don't know.
Oh, no. Like, so if you, like, start a trial in state court and then it, like, gets appealed or something, you stay in the state court system. The only way it, like, jumps is if the state Supreme Court or the highest court in the state gives a ruling and it's a constitutional question and it gets, like, granted for cert to the Supreme Court. I guess, technically Supreme Court's federal, but, if something starts in a federal district court, then it moves up to the appeal circuit for federal. So it stays, within its lanes.
Okay.
Huh.
Well, there you go. 3 for 5. Not terrible.
Oof.
Definitely some tricky ones there, but, you're still beginning. You're still learning, so it's not.
Yeah, but oh man, I'm not gonna. What a sour note to end on. That the Civ Pro one I wanted so
I'll
bad.
save this file so we can go back to it. Again, we got plenty more questions here. There's 20. What did I say? There's 21. Yeah. So, we'll see as you keep taking more classes and learning about different types of law, whether you can answer the other ones. So, all right. Anything else you wanted to discuss on the show, or?
No, I mean, that was fun.
Yeah, we hope the listeners learn something. Maybe nothing, but.
Yeah, to be fair, there's a lot going on without having like a kind of foundation or base to like orient oneself. But I mean. And I don't think like removal is going to be a pretty, pressing topic for an everyday person. But hey,
let's end with an easy, like, quick hitting one here.
Oh no.
Yeah, you can get this one. What B word signifies a legislative body that has 2 bodies or chambers?
Bicameral.
There you go.
Whoa. Yes, let's go. That's some like 4th grade.
Government. This other easy. This is the easier question one. I think they're harder as they go on. Yeah. Okay, so yeah, there we go. That's it. I will let our listeners know. Anchor got bought by Spotify, I think like a year ago, whenever it was, and we've basically had the same sort of system. Like, it's been the same setup. You've noticed there's a new link, but the old link will always redirect to the old one, so it's not a big deal, and you should still be able to find out where you can find podcasts. They did change the requirements for ads. So unfortunately, I know it's a shock, but our podcast doesn't have enough listeners to meet those minimum qualifications for ads now.
Oh my gosh, Spotify.
We used to, but now we don't. So, yeah, I mean, I'm just going to say keep listening, but, tell your friends, I guess. I mean, we're kind of close to the line, but we are going to need a bigger push. So.
This summer, when I have some time, I'll look into seeing if we can sue Spotify for you.
We're going to look into suing Spotify, whether it's state court or federal court. We'll figure that out later. Yeah. Thanks for listening. Nathaniel, thanks for coming on. We'll test your knowledge in the future.
Absolutely. Great time.